things where, I might have to literally jump up and help with Josiah in particular.
Yeah. Yeah. I do a lot. I'm a younger grandparent, I guess. So it takes a lot out of a grandparent. I do a lot of um, backup for my grandson. He's 3. So
Yeah.
and there's only one, and it's tiring. So this is kind of fun. My cousins, I have many cousins. She's quite sick, and I'm out with my sister to see her. She's got some terminal cancer. So that
Sorry.
was the reason to come out. Well, it
I'm
was a long flight. That was what
good.
I can
Good
say
evening.
about it. It was an easy flight, but it was a long flight. That's all the way across
Yeah,
country.
I'm.
So
Good evening, everyone. I'm
it's
calling to
not like,
order
although I'm seeing some things, I'm doing some other
the.
things when I'm out.
Can you mute her? The horse. I'm calling to order the December 13th, 2023 Southborough Zoning Board of Appeals. We do have some of our members on Zoom this evening, and some of us in person. Do I need to read all that? No, that's for you. All right, we have two items on the agenda this evening. Go ahead, Laura. Yep.
The Board of Appeals of the Town of Southborough will hold a public hearing in the Thomas J. McAuliffe Hearing Room of the Southborough Townhouse, 17 Common Street, and via Zoom, Wednesday, December 13th, 2023, at 7 o'clock p.m., with regard to the petitions of FD 120 Turnpike Road, located at 120 Turnpike Road, map 37, lot 120-4, Southborough, Mass. The petitioner is seeking a comprehensive permit under MGL Chapter 40B, Sections 20 to 23 and 760 CMR 56 to construct a 60-unit apartment building on an undeveloped portion of the 120 Turnpike Road lot. In addition, the Board of Appeals of the Town of Southborough will hold a public hearing in the Thomas J. McAuliffe Hearing Room of the Southborough Townhouse, 17 Common Street, and via Zoom, Wednesday, December 13th, 2023, at 7 o'clock p.m., with regard to the petition of FD 120 Turnpike Road, located at 120 Turnpike Road, map 37, lot 120-4, Southborough, Mass. Petitioner is seeking a special permit to modify the 2005 special permit decision due to the proposed use of the shared driveway to serve MGL Chapter 40B comprehensive permit project on the southern parcel.
Thank you. Okay, just before we get going, just a few things, just administrative. Anybody coming to the microphone should identify themselves, name and address if you're a Southborough resident, or name and what your role is in the application. Similar to what we decided on on another 40B project. My thought remains, it's still that no good purpose is served by having really late night meetings. So our goal is to try to finish before 9 p.m. on any given night. As it is with every hearing, people who want to speak have the ability to do so. If in public at the rostrum, online, you also have the ability to speak. But when you do, again, name and address. And I ask everybody that they just please be respectful in whatever they raise as issues. So, having said that, do you have a presentation?
We do. Yeah,
Okay.
You guys are ready for it. Good evening, everybody. I'm Brian Charville, the Chief Operating Officer and General Counsel for Ferris Development Group. We're the developer behind this project. So good evening to the chair, members, town council, and also the folks that are in the audience, especially the board members and the folks that are listening at home. As you noted when you talked about the agenda, there's a comprehensive permit, a 40B, before you tonight, and we look forward to introducing it and also talking about a special permit modification because of the pre-existing 2005 special permit. So we'll start with the comp permit and then talk about the special permit change. This is, I want you to know, a great project in a great location for the town. Few, if any, potential 40B lots in Southborough could be as well located and unaffected by direct residential abutters as this site is. And what we're proposing is 60 apartments with this project. So I want to just kind of set the stage before we introduce our project team, which I'll do in a moment. Why are we here at all? As you all know, because you have 40Bs pending before you now, the Commonwealth decided back in 1969 that it was important that there was a common public interest in promoting affordable housing and the production of more housing. And that's why 40B was passed in the first place. So it's Chapter 40B, Sections 20 through 23 under the Mass General Laws. As you know, that law makes this board a super board, if you will, where local approvals are consolidated here as opposed to spread out over other local boards. And in addition to that, this board has the power to waive local bylaws as part of issuing the comp permit. Here in Southborough, according to the most recent subsidized housing inventory, which was dated pretty recently as of June 29th this year, there were a total of just 297 subsidized housing units, or SHIs, which is against a total of 3,734 housing units in town. So that means that Southborough's percentage today is just 7.95%, below, as you all know, the 10% operative hurdle that would, if the town reaches it, take the town into safe harbor. So that's why we're here. The town's exposed in that sense. In order to get to at least 10%, based on this math, the town needs at least 77 more SHIs. So we're pleased tonight to tell you about our proposal, which is for a project called the Alexandra, as staff noted, at 120 Turnpike Road. As I began to say earlier, we think it's a perfect building at a perfect location. It's secluded, but at the same time has direct access onto State Route 9 or Turnpike Road. It also will have very limited impact on secondary roads because, again, you don't have to go on a secondary road to get to the main road. This will go right via driveway to the main road. And as I mentioned, there are no direct line-of-sight residential abutters. It's a very, very unique site in that way, and there's plenty of land to do this project. So if you don't mind bringing up the PowerPoint, thank you. And before we go further, I'd like to introduce our project team. So again, I'm Brian Charvel, Chief Operating Officer and General Counsel. With me tonight are David Ferris. He's the owner of Ferris Development Group and also the owner of FD 120 Turnpike, which is the applicant before you. Mr. Ferris lives here in Southborough along with his wife and 4 children, and he's lived in Southborough since he was a boy. So the town means a lot to our company. We're based here, as I said, at 118 Turnpike, and it means a lot to him and his family. Also with me tonight are Lou Levine. He's with the law firm of D'Agostine, Levine, Parr, and Netburn with an office in Acton. He's our 40B special counsel. I think, is Mr. Tatro here? We have a civil engineer, James Tatro, with Azimuth Land Design. I think he has another hearing tonight. His office is at 118 Turnpike Road in Southborough. Kristen Costa, our 40B consultant. She's with LA Associates of Chelmsford. And then finally, Monty French, our architect of Monty French Design Studios of Boston. So Monty and I tonight are going to introduce you all to the project. Don't intend to take a lot of time. We look forward to getting your initial feedback, talking about a plan for the next hearing, and hearing any comments that are made by the audience. So let's begin by looking at the site. If you don't mind bringing up the next slide, please. So this shows the entire parcel of 120 Turnpike, and I'll try to carefully outline it. You have Route 9 here, Turnpike Road, and the lot goes down this way and cuts over and follows down here, up around these ponds, and then back to Turnpike Road. The improvements today are 118 Turnpike, a 3-story office building, and 120 Turnpike, also a 3-story office building, and then associated parking. There's this overflow lot and parking here and here serving the 2 office buildings. And as I mentioned, the detention ponds, which ultimately flowed to the reservoir. For familiar point of reference, the Starbucks in Tomaso's is just off screen to the left. And then there's the nursery up here to the right. So as I mentioned, just thinking about what the direct abutters are, there's, and then where we're proposing that 40B is back here, which is currently undeveloped. The total site is about 20 and a half acres. Part of what we'll ask you to do with the comprehensive permit, which I'll talk about a little bit later, is to subdivide the lot. It's all one lot now, and we propose there be a subdivision along the zone line, which is here. To the north is the Highway Business District, this area, and to the south is Residence A. And today, the southern portion is completely undeveloped and forested. Again, the site's attractive because there's an office building here, no residential abutter, office building here at 134. There's town conservation land then here to the southwest and the southeast. And then there's the nursery and garden area there and DCR land, which flows into the reservoir. So it's an attractive site in that sense. To be clear, this isn't one of the 40Bs you sometimes may see where the applicant before you is under contract to buy the lot. FD 120 Turnpike, the applicant owns the lot today. So there's not a question about title or anything like that. The next thing I want to tell you about is the driveway. Today, there's an existing driveway, 28 feet wide, right through here. And there's a few different outlets where you can turn toward 118 Turnpike, go down further, and go toward this area, which is a flagpole and a rotary, or continue down to enter the 120 Turnpike lot. Our proposal is that this existing driveway would also be used to serve the 40B. So you would just cover existing pavement along here, and then there'd be a new driveway which would ascend up the hill here to the building itself with new associated parking. Even after the 40B is approved, there would still be on this remaining parcel the 2 office buildings and their parking. The driveway, as I mentioned, upslope I think would be 24 feet wide and less than 600 feet long. And of course will be designed to accommodate fire access. If you don't mind, next slide, please. This is a bird's eye view of the 40B site itself. Zoomed in a little bit more. So the building, if built, would contain 60 units, 60 apartments. They'll be apartments, not condos, which is important because, as you all know, if there are apartments, all 60 will count toward the town's SHI ratio, as opposed to condos, which don't count the same way. And of the 60 that we're proposing, 15 of the units would be designated affordable. The building's proposed to be 4 stories tall. As you see, the base footprint would be 85 by 250 feet. And you see some of the amenities designated here, but I want to tell you about all of them. There's proposed to be a dog park and a playground. There will be some garage units for folks that wish to rent enclosed garages to park their cars. We also propose that there would be a dog washing station on the inside, which we've been told is important to apartment renters. Of course, bicycle storage, an elevator inside the building, and to connect with the existing conservation land, there would be connections with existing hiking trails. We think it's notable to point out that the building's parking ratio will be 1.9 to 1, which is high for a project like this. Those ratios are often 1.7, so we're above that with the project. And 114 new parking spaces. And you see depicted there will be a new on-site septic system, and percolation testing for that is complete and is satisfactory. So at this point, I'd like to turn it over to Monty French, our architect, to talk more about the design and the unit mix.
Thank you, Brian. My name is Monty French. As Brian mentioned, I'm the architect for the project working with Ferris Development. I guess if we could go ahead and move to the next slide, we can get into the architectural aspects of the site. So I won't rehash what Brian already introduced with the site layout, but you can see here that as you approach the site, we've noted the main entry at the front most close corner to the drive lane. We also have a side doors that folks can access the stairwell. Over off to the right, you can see our unit count. As Brian mentioned, we have 60 units. We give a breakdown of the unit types, 37 one-beds, 17 two-beds, and 6 three-bed units. We've also broken them down by floor. You can see at the matrix up above. And I believe we might be a little bit off on the parking. We show 112, but I think it has been updated since we've done this particular presentation. Next slide, please. So here are preliminary plans that show the unit layouts and mix of units per floor. As Brian mentioned, we have the dog wash station that you see to the lower right and the bike room, easily accessed from the main entry that is in the upper right-hand corner. Near the upper right-hand corner, we also have the mail and package storage room, the main elevator and stair, elevator lobby, and resident lounge and amenity space. Next slide, please. This is a typical floor showing the mixture of 2 beds, 3 beds, and 1 bed units. Fairly self-explanatory. You can see each of the units, we provide some outdoor space with the with the decks off of each unit, trying to give a little bit of private outdoor space to each of these units. Next slide, please. This, we wanted to kind of zoom in a little bit to give folks a chance to see the type of unit layout and efficiency of the unit. Very generous living in common area spaces with dining, living, kitchen. We have some units that have the one-bed units with the office study rooms and your typical bedrooms, primary bedrooms, and bathrooms. In this particular layout, we're showing mechanical spaces accessed off the hallway for ease of access for maintenance crew to not disturb the tenants is one thing that we've considered. You know, those things will be fleshed out as we move through the project. Next slide. This slide is showing a depiction of the main long elevations. Again, a 4-story building. Looking at the arrangement of the materials, the base of the building is a masonry-like material. And then moving upward, we'll probably have a trim band that separates the clapboard siding from the masonry. And then along the top of the building is a cornice, architectural cornice. And then you can see the relief of the balconies that help kind of break up the facade, the length of the facade, to give it a little bit of scale and depth and relief. Next slide. These are just the short ends of the building on each end, more of the same materials with the masonry base, clapboard, body, and architectural cornice. You can see that we've also shown the head house of the elevator and the stair up above. Next slide. We've also gone ahead and tried to depict as close as possible how this would be arranged in the site and how it would be kind of feathered in with the landscape, existing trees, but new landscaping elements with parking islands and plantings out front, but also depicting the materials that we see in the building with the clapboard siding, the masonry-like base, and then the insets are more fiber cement panel type material. The color, is subject to change, but, we've always envisioned a kind of a warmer residential palette. But you can see that this kind of breaks down the scale of things. In this particular image, you can see that we have a covered entry to the main entry for the residence. Next slide, please. A corner view, again, of the same end of the building, but just to give you a sense of the shape and scale and density of the project and how things break down and is nestled in with the landscape. Next slide, please. Zoomed back kind of very near where just off to the right of where the driveway entry is, but again, to give you a sense of scale, depth, and arrangement of the building, we've got a variation of the body of the building, some wider pieces and narrower pieces to give a little bit of rhythm and balance to the building. And I think that concludes the architectural portion of the presentation.
Thanks, Monty.
Yep.
So in addition to this board's review and the comprehensive and special permits, we will be applying to the Conservation Commission with a notice of intent. So we'll need an order of condition for any work that's going to be done within the 100-foot buffer or the 20-foot no disturb area.
Brian, I don't want to, with David's indulgence,
Yep.
Get ahead of it or interrupt your flow.
Thank you.
I did note that there are no wetland waivers requested.
All right, we'll be sure to,
The
Yep.
local wetland bylaw, you have some stuff within 100 feet.
yes.
Is that, Mike, please? Sorry.
As you go through that, I think you need to update that waiver request for the work that's under the jurisdiction of the local wetland bylaw. I see that you have Goddard Consulting. Goddard should know what they would be looking for. They have pretty good 40B experience, so that's just, I didn't want
We
to,
will.
while you were talking about
Right.
wetlands, I
No,
just
that's
wanted
fine.
to flag it.
Yep, thank you. Before filing here, the project did go through the site eligibility process with Mass Housing. And that did result in a project eligibility letter being issued on October 16th of this year, finding that this project is eligible under 40B. And during that site eligibility process, this project received the clear, unanimous support from the Southborough Select Board. As they gave feedback to the state, they said, quote, "This project is in the best interest of the town of Southborough," end quote. And we just want to take the opportunity tonight to thank the Select Board for their support of the project. It is noteworthy, and I want to be sure to point out that this project, if built, would be in the Residence A zone. So it is residential and residential. And it's noteworthy that this project is in the vicinity of zones that the planning board is looking at as they do mapping to comply with the MBTA communities law. We looked at the distance, and this building, if built, would be within 2 miles of the MBTA commuter rail station. So there is some consistency there, that this is proposed multifamily in areas where the town is looking at building or allowing multifamily by right as required by state law. And I'm pleased to inform you that this project will have preference for Southborough residents when it comes to occupancy. So we're really pleased to offer that. I want to be sure that we touch on the fact that, as noted, and if you don't mind maybe going back to the first aerial slide, the first site plan slide, thank you. Yep, the first aerial that shows the whole 120 parcel. Yep. So I want to be sure to touch on the fact that the proposal does, as part of this comprehensive permit, ask this board to subdivide the lot, again, along the zone line. Highway business to the north, Residence A to the south. It's one lot of 20 acres, but if subdivided, there would be 12 acres to the north and 8 acres to the south, the 40B lot. Attorney Levine and I have reviewed this question, and we talked with town council about it, and we all agree that, as a matter of law, this board has the legal power, as part of issuing a comprehensive permit, to subdivide the lot. That's established under 40B, and to create this subdivision. As I mentioned, as you know from your other projects, 40B says this board acts for other boards, and the power is consolidated here, with the exception of conservation. And so we do ask, as part of the application, that your ultimate decision allow the subdivision as well. And even after the lot's subdivided, again, there will be an access easement that goes down the existing driveway to reach the 40B's driveway up the hill. And secondly, I want to mention, also on your agenda, was the special permit modification. So there's a 2005 special permit, and it said 2 things. One, that there may be an office use that exceeds 50,000 square feet. And I think it was for a prior tenant to one of the 2 office buildings, probably Olympus. And the second thing it said is that 2 buildings could be on 1 lot. As you all know from other cases you've heard, unrelated to 40B, it just takes a special permit to have 2 buildings on 1 lot. And so that's why they were before you in 2005. But because it's out there, town council recommended, and Attorney Levine and I agree, that it's appropriate to modify it, because we would hate for this board to issue a comprehensive permit and have a special permit out there that was somehow inconsistent or that didn't address the fact that now there's a 40B. So we're really trying to just cross Ts and dot Is. What we propose is that the special permit be modified so that it just reflects the fact that the shared driveway is used to access the 40B. Again, we know from the traffic study that was submitted to your board that the traffic from the project will be almost immaterial. I think peak rush hour, morning and night, it's 22 and 26 trips in an hour. And that's aggregate in and out. So it's we're talking about a trip every, 4 minutes, 5 minutes. It's pretty spread out. So we know that. We also know that this existing driveway is 28 feet wide, which is plenty of width to accommodate the flow from the office buildings and the 40B. And there's enough width there to have vehicle passage as well as pedestrian passage. There could be a sidewalk, but right now it's just curb-to-curb paving, 28 feet. And again, the traffic is not going to overburden that access driveway in any way. So the only other thing I'd say about modifying the special permit is that even after being subdivided, this office building parcel in the highway business zone would be conforming. And so we don't sort of cut off our nose to spite our face by imposing the subdivision or asking for it to be imposed. And that's really it for our introduction. So we look forward to hearing your feedback. Thank you.
Thank you. Laura, you said Mike, I believe you had raised your hand. Mike Robbins, do you have a question?
Yeah, thank you. I wanted to make sure when any of the speakers are speaking that their microphone's on. I believe you had an earlier question or comment, Dave, and I could not hear you. Sorry.
Okay, sorry, thanks. Okay. So, I mean, relative to the presentation, I don't know that I necessarily have something specific to ask you right now. I mean, there were some things that were raised by the planning board that we'd need to address. But before we do that, I would like to just see if any of the board members do have anything that they want to ask. And I'll begin with the folks that are here. Jamie, did you have anything, or?
You may be referencing this. I can't remember if it's the planning board, but I read somewhere that 3 stories was suggested versus 4.
Oh, right.
I
Yep,
yeah.
Yeah.
So maybe we'll talk about that later. But
think- yeah, I think-
that was really the only thing that I felt we needed to talk about. Overall, I drove by there today, and I do agree. I think it's a good spot.
All right. Doug, did you have anything you wanted to ask?
I think you answered already one. The first question I had was the remaining office building being conforming after the subdivision, but I think you just addressed that. So I would just ask if town council agrees with that, or is that something that we reviewed to see that if the subdivision were to take place, the remaining office buildings are conforming on the remaining lot?
I'm not sure I would characterize it necessarily as conforming or non-conforming. There is a variance that it benefits from that has kind of brought it into compliance. That variance is kind of an unconditional variance that was granted a number of years ago by this board. But what I would say is that when the subdivision happens, if it happens by this board, and this board does that, 40B can be used to waive things with respect to the 40B lot. What it can't be used for, and I think this might have been Brian's point to a degree, is to waive any either existing or resulting nonconformities on the other lot. So if by subdividing the back half of it off, it created a zoning problem there, then that would be a problem for them, that they would have to address in some other way, a variance or otherwise. It could not happen by virtue of this board fixing it for them. So what I think is important to say is that this subdivision, if we take off the rear lot, doesn't cause any new zoning nonconformities with respect to the remaining office lot. I think that's probably a better assessment of that.
Okay.
So,
Okay, great. I mean, I have other minor questions, but they can be later. Thank you.
Okay. Online, Mike, did you have anything you wanted to ask?
I did, thank you. One of the questions I have relates to access to Route 9 and when, and, my only concern is, will Mass DOT block entry or access to that? Could they deny access and then, now we need to provide access through other means that now would go through neighborhoods? I was unclear on whether that approval was going to be granted or if it's pending and how that applies.
We have not requested it, but we'll be happy to look into that for the next hearing.
Okay,
Thank you.
that's my only question for right now.
Okay, thanks, Mike. Yeah, I know that came up before. I was just kind of looking for where that was. Paul, did you have anything to ask?
No, I have nothing to ask at this point. It was well presented. Hard to hear at times, as Mike said, but well presented, so I was following along nicely. Thanks.
Doris?
I had a question somewhat similar, a little different trajectory than Mike's. If it's possible to bring up the driveway map and make it as large as possible as to how it felt like I weeded through when I came out to site. Weeded through. Is that going to be changed in any way as they give the easement out to Route 9? It's just
The driveway shown there will remain straight, running north to south.
to get back to the corner.
Yes, and then up the hill from the new driveway at the corner.
Okay, maybe the fact that I felt I weaved through, or I'm just not that familiar with the property. I didn't feel as though it was straight. But there's a straight axis, and then you take a turn in to the new property.
That's right.
No, I really don't have further questions at this point.
All right, thank you.
Thank
So,
you.
We did receive a letter from the planning board where they raised, first of all, some legal questions. Jay, do you mind just addressing the,
Yeah, I'm happy to.
raised? If that-
Actually, the planning board has, and the town planner has been really terrific in flagging a few issues that we were then able to speak with the applicant about and make sure that they did things like file the companion application for an amendment to a special permit. I've had some prior discussions with the town planner on some of these and hopefully address them, but I think it's great that they've brought them to light because I'm aware of at least one letter from an area resident who raised some of the same questions. So I think it's good to clear it up. You know, the question, I've been doing 40B work for a really long time. Attorney Levine has as well. The question regarding the subdivision authority of a zoning board has long been questioned as whether or not the zoning board could have that authority. That issue has been resolved by case law. The question as to whether or not you can affect a subdivision that would have cleave off one 40B lot and leave a conventional lot has been a kind of a side question. The Housing Appeals Committee has said that that's okay, provided that, again, as we discussed previously, you can't use 40B to cure any resulting nonconformities on the conventional lot, but you have the authority to take this lot off of it if you're promoting, again, the affordable housing. So I think that that's important. The issue that the town planner then flagged is, okay, well, we have an underlying special permit for an office building that contemplated a much bigger lot and also contemplated specific traffic flows, directions, peak hours, parking, all those other good things. And that's 100% correct. That special permit was issued by the Board of Appeals, and without an amendment to that special permit, an approval of the 40B would leave that project non-conforming and potentially subject to enforcement. So that has led the applicant to apply for the amendment to the special permit. Another question was related to the issuance of a variance, and it's kind of related in a few different ways. I looked at the original variance for the frontage. There was no conditions on it. If there was a condition on it that said something like only 2 buildings on this lot, and where we'll reduce it, that would be one thing, but there isn't. And in other words, they would have had to get an amendment to that variance as well. But that variance was for frontage. It doesn't give a condition on it. It remains unaffected. There's not going to be less frontage. Part of the subdivision is not creating a separate roadway lot. It's really just through an easement. So the frontage remains unchanged. The planning board does raise an interesting issue under section 174.14 that talks about, it says, no lot shall be reduced in size, altered, or subdivided, and no part thereof conveyed or transferred if said lot or buildings or structures thereon and the uses thereof already are or will cause thereby to be not in compliance. So again, I mean, I don't think they're drawing any conclusions one way or the other, but I don't interpret that provision to cause an additional issue for this applicant, because there's no non-compliance created by this division. There's existing kind of non-compliance, but that was cured by virtue of the variance. So when the applicant has taken some care to make sure that no new noncompliance or new nonconformity will result on the conventional lot, the non-40B lot. So I think that it's an important point for us to address, but it's not an issue that I think is a disqualifying event here for this, and that's been my opinion on it. Even if it were a question on that, then there's certain authority under Chapter 40B. If like the new nonconformity was on the 40B side, obviously of the lot line, then that can be addressed. The planning board also raised a question as to potential open space requirements per lots that exist under the Subdivision Control Act or under their local subdivision regulations. You're doing a subdivision here, so you are the subdivider. The requirements for open space aren't really requirements. The board, at its discretion, may require set-asides for open space. So there's no hard and fast requirement under the regulation, the local regulation, to require that open space. But the board retains that discretion under subdivision control for either of the potential lots. So the board will have to weigh, ultimately, how it feels about the remaining open space on the lot, the availability for recreation and open space. Obviously, they've tried to provide some recreational opportunities, open space, and obviously they abut some significant open space and conservation parcels. So I will expect that we'll be discussing that, but again, not a disqualifying event. I think it's important and great that a planning board takes the time to respond substantively and help a zoning board out with things that may be foreign to that zoning board of appeals. So I hope my response is somewhat helpful to that. The remainder of their letter really goes to the other merits and important components of the project, some of which have already been discussed and I'm sure we'll get into, and those aren't quite legal issues, but I wanted to make sure that I address some of the legal issues that the planning board raised, and I'm certainly grateful that they took the time to do that.
You want to go?
Yes, thank you. Mimi Latrelma, Chair, the Chair of the Planning Board, and the Planning Board is in session tonight. We have 2 members here and 1 is on Zoom. Per this regulation, CMR 76056.05, it's required that a preliminary subdivision plan is included in the comprehensive permit application, and that was not included. And I'm hearing that the intention is that there is going to be a subdivision, so I'm wondering why that was not included.
Yeah, but if you'd have to just recognize yourself and come to a microphone.
As Brian indicated, my name is Louis Levine. I'm the attorney. I don't want to get into too many technicalities. And I agree with what Town Council had overviewed a moment ago. But subdivision control, and I'm being very general here, is the creation of new road where you create new frontage and therefore permit buildings, lots to be created. And subdivision control, when it was created in the 30s, was previous to that. People bought off plans. The roads never got built, and they had no recourse. So in the 30s, legislature said, well, towns can have subdivision control. They can have standards to build roads and all those things that go with roads, like drainage and stuff like that. We're generically subdividing a lot. Okay, we're not creating a subdivision road, which is, I think, an anomaly that we're going back and forth on here. All right, we're simply extending a driveway. It's a private driveway, and the lot that Brian mentioned is just a lot that's created, which is a process that would be under the subdivision control law as an exception, an approval not required lot, right? Because we're not creating any new roadway. Now, I don't want to quibble back and forth, okay, but I just want to make it very clear that the subdivision control is when you're laying out roads. And so if this was a single-family development, we were going to build so many houses, townhouses, or we were going to have so many apartment buildings, but they were going to be on separate lots, then subdivision control, or at least your concern about the town's and planning board's regulations, would be a important consideration. But we're not doing that. We're just simply extending a driveway to our lot. And our lot, that's it. And under the planning board's powers, which ergo are now your powers, they have the authority, if somebody comes in and says, I have a plan and I want to create a line down the middle of it, they can sign that plan. It's very normal. They do it all the time. In fact, they do that more than they do subdivision control, that they sign the plan as approval not required, meaning it doesn't, that is like a negative definition that it doesn't come under subdivision control. It doesn't need approval. So the comment from the chairman about a preliminary subdivision would be applicable if we were laying out lots and that type of thing. And I think, 40B, as Brian indicated, has been around a long time. And historically, for a long time, it was a single-family home process with apartments kind of being in the minority. And then maybe in the 80s and 90s for sure, apartments took over from the single-family homes. And so, but we're not creating subdivision. We have a full plan here that shows our full development. In fact, the regulations talk about preliminary architectural plans, preliminary this, preliminary that. Well, and Jason can speak to it better than I, but your regulations, like most towns' regulations, require a lot more now, a lot more than the 40B regulations initially, were implemented in 1969. So you have the data, you have the information, we have the drainage calculations, we have radiuses and traffic counts and way more, than if this thing was being considered as a preliminary subdivision under the regulations. But again, my point is, all you're being asked to do is to cut off a lot, not to approve any road.
So I'm going to
No, I was going to ask
I'm going
you
to
to.
disagree a little bit with Lou and agree with Mimi. It's likely a distinction only a lawyer could ever love, because I think we end up in the same place. But they can't do an A&R. What's called an A&R is an approval not required. It's an action that is taken outside of zoning. So. And there's no local bylaw on it, so they can't waive a state statute. The state statute has minimum frontage requirements for lots that will serve as building sites. This board has no waiver authority over that, so it couldn't be a simple A&R. I do think, and it didn't worry me too much on the plan set that they provided, because it does show more than one lot on it. I do think at some point, probably sooner rather than later, we should see from the applicant an actual endorsable plan that shows the two lots. Pretty simple. Their engineer could do it in just a few moments. So I think it has to be more of a formal subdivision and not an approval not required, which is something less than a subdivision. Along with that, in addition to maybe bolstering your waiver list, or definitely bolstering your waiver list with wetlands things, you should take the time to go have your engineer go through the subdivision regulations, because it's minimally, as Lou suggested, a subdivision. There's a number of regulations that either just don't apply or that you may need waivers from, and I think that that should be addressed too. I don't have any quarrel with the notion that we're going to get to the same place, but Ms. Luttrell is 100% right, that at some point, we're going to need to sew this up in some kind of adequate subdivision plan. Whatever we call it, but the legal mechanisms available led me to conclude, when I was speaking with the town planner, that we have to make it more of a true subdivision division rather than having a plan that says approval not required, just because of what the statute says. It's somewhat of a distinction without a difference, but it's important that we get the law right on it. So,
Okay, thank you. All right, Ms. Luttrell?
Yes, thank you. Just to point out, though, there's one lot that would be waived from town regulations, and the other lot created would not, because it's creating two lots.
correct.
Correct.
Correct, yeah, I think Jay was saying that the subdivision, we would only apply the waiver to the newly
To the
created
40B
lot.
lot.
Correct.
And back to the, that Attorney Talaman did reference 174-14, that no lot shall be reduced in size, altered, or subdivided, and no part thereof conveyed or transferred if said lot or building or structure thereon, or the uses there already are, or will be caused to thereby be not in compliance. So that lot is already not in compliance because it has variances for both setback and frontage. And a variance does not render the structurally legally non-conforming, so it couldn't get a special permit to alter or subdivide that lot because it's not a legally non-conforming lot. It's legally not in compliance, but a non-conforming lot has that benefit of the special permit. So I'm concerned that when the lot is subdivided, that lot with the two office buildings on it will not be in compliance with our code, because a non-conforming lot can't be subdivided.
And it's an interesting issue. I just disagree a little bit, because I think it's somewhat of a misnomer to compare what it says here, which says to be made non-complying or will not be in compliance with the town zoning code, and to analogize that to other case law that relates to pre-existing non-conforming aspects of a particular lot. The lot was made not conforming, but got a variance from compliance. I think that it is not the same thing to try and bootstrap, so to speak, case law that talks about variances and what their relationship is to pre-existing non-conforming structures. Here, this lot exists with the benefit of a variance that cured a non-compliance. Nothing about this is changing that. So I don't see how, or I don't agree. I see how it can be a very confusing issue, but I don't see how necessarily, or I don't agree that it necessarily creates a problem for the applicant. To the extent that there is ever an enforcement request against this applicant, or the board has significant concerns about it, it can be addressed later, but certainly I could see how there's room for some disagreement on this. I just think that the view that we would be rendering it non-compliant, or that it's already non-compliant, is not in harmony with the way it would be interpreted, because again, they have the benefit of a variance that cured non-compliance. It didn't make it pre-existing non-conforming, it made it post-existing kind of conforming, so.
Sorry, just to clarify, the variance was on what exactly?
Frontage,
On frontage?
And setback, two variances.
yeah.
Okay.
And those are not changing.
Right, yeah, okay. Thank you. Okay. Did you want to continue, Ms. Michelle?
Just so the application for this special permit and the site plan, it appeared that the lots were being created through a site plan, through a special permit modification, which I don't think you can do. It says on the plan for the special permit modification that this site plan is to create a separate lot. So I'm just concerned if you approve the modification, it's going to approve a separate lot where a subdivision is required.
But I think we can't, so we can't really approve the subdivision without a full plan on that, correct? Isn't
Correct.
that's
Yeah,
exactly what you
we're
raised.
going to need a plan that has the signature lines,
Yeah.
you know, and I think, again, I think Ms. Luttrell is correct that you should, it may change, but I think we should at least see what that plan would look like. That just shows the raw new lots on it. A simple engineering
Right.
plan on that.
And so what is the outlook on that? Would you be able to provide such a
Oh,
thing?
yes, certainly,
Mhm.
this week,
This week?
yes.
Okay.
So I request that you don't approve the modification of the site plan until that comes in, because that modification looks as if it's subdividing the lots.
To be very clear, if I may, we do not intend at all that the special permit modification be a vehicle to create two lots rather than one. That is squarely part of the ask for the comprehensive permit. The special permit modification is just to address the shared use of the driveway. That's
Right.
it.
Okay. All right.
It's just that that's what it said on the plan that was
Right, we
filed with
should-
the application.
Mr. Chairman?
We should note too, just in a sec, Lou, that I believe in, and I'm not sure if they've done it already, Mimi, but have they applied for the site plan modification yet? So
No.
there's an additional approval that they will need from the planning board because site plan applies here for the conventional lot, not the 40B lot, but the existing office park is going to have to go through some further review from the planning board at some point before they could move forward.
Mr. Chairman?
No.
And Jason?
Okay, yes,
I'm
go
sorry.
ahead.
And I think, Jason and I, in terms of our experience in 40B approvals, it's very, very, very common that with the comprehensive permit that the board issues, or a board issues, a plan is recorded at the Registry of Deeds, signed by the Board of Appeals, that represents the project plan, or whatever you want to call it, for the approved 40B. And that plan is signed by the Board of Appeals. Otherwise, I can't record a plan, but I can record it when I have a 40B, and in fact, that's the way it gets recorded. I can't record it because the statute and regulations otherwise only require the planning board to sign a plan, whether it be a subdivision plan or an approval not required plan. But we need to give you a plan, the final plan, that you will endorse if you approve the comprehensive permit. That's it, and the comprehensive permit will make reference to the plan to be recorded so that everybody knows what you approved, and it's not just an 8.5 by 11 paper, and then we have to go to the planner's office to see what you actually approved. So that will be submitted with an endorsement box. All right, we can do that now, and we will, with any additional data, and I don't want to quibble with Jason about the applicability of subdivision regulations, because we'll either show our conformity to them or ask for waivers. To me, it's angels on the head of a pin. All right, but you will be endorsing, and I'm sure Jason would tell you it's good practice to record the plan that shows the project.
It's going to have to be recorded.
Otherwise, we just have a 8.5 by 11, written, and nobody really understands what gets approved. So, again, you are the board of all boards: Board of Health, Conservation Commission, under local bylaws, and the planning board. And that's just, the statute was intended to streamline the approval process to allow housing to get built. And going to one board, somebody 55 years ago thought that was a good idea rather than going to multiple separate boards. That's why we're here tonight.
There's no argument there, but the planning
Right.
board certainly does have the opportunity to comment.
Oh, I don't deny that.
Yeah.
The other thing, there was a stone wall along the eastern, a historic stone wall along the eastern portion of the 40B lot that was much discussion during the site walk that the proponent committed to saving, but it doesn't show up on the plans. And then the last thing is just the 4 stories is not fitting with the town. There's no other 4-story building in Southborough. Thank you.
Thank you. Yeah, with respect to some of the issues, I mean, I do appreciate them being raised. I do think they're valid points to be brought up with as we go along. My understanding is what we're doing is still relatively early, but we do want to address the special permit if we can. Do you want to?
Hi, everyone. I'm Freddie Gillespie. I'm Chair of the Southborough Open Space Preservation Commission. We submitted a letter within the time frame to, let me just grab this up, to Catherine Miller, and we never received a confirmation, and then I found out it wasn't in your packet. I have an email from her, which I thought she had sent to you with a copy of our letter because it should have gone in your packet. This is the Open Space Preservation Commission's comment letter, and she wrote me on 11/30 acknowledging receipt, and she apologizes for not addressing it, our letter, in her eligibility letter. But she said she can confirm that our concerns were addressed in the PEL and/or would not preclude Mass Housing from issuing a PEL, and to contact her if I had any issues. Well, in our comment letter, we raised concerns about the legality of building on this lot, which we, from our knowledge of prior history, we having legal representation, but we still do not believe it's a buildable lot, similar to the concerns that the planning board has given. So I brought that up with her, and her comment to me is, they don't look at the zoning issues. That's up to the ZBA. So the fact that they issued this, positive PEL does not mean that the ZBA shouldn't seriously be considering the concerns about the zoning issues. And I want to just say a couple of things about what you've heard to this point. In the Open Space Commission, I'll forward that letter to you so you can have it. We have lots of comments about the actual project. I attended the site walk, so we felt very comfortable with some of the response we got from the developer and his representatives at that site walk to do some mitigation for some of the concerns we had. However, the first thing is this a buildable lot? And I think that needs to be addressed. And I want to say a couple of things about this. How we got where we are right now is the constant comments from the applicant and other people, the Board of Selectmen, the lack of residential abutters, I have to say, does not make this a perfect location. The big abutter is Breakneck Hill Conservation Land, which is the premier open space parcel of the town that has over 25 years of hard work on conservation values, species that are endangered, at risk of extinction. We've been multiple committees, the Stewardship Committee, which I also believe wrote a letter, the Open Space Commission, have been involved for over 20 years. And one thing that is glaringly obvious when people say, and no offense, but I drove by. Did you walk by? Did you spend time on the conservation land and try to visualize what the negative impact to wildlife habitat? And I suggest that we had a Board of Selectmen who, for various reasons, we do need affordable housing. I'm an affordable housing advocate. I have been working towards that for over 20 years with Community Preservation Act, proposing projects, bringing in people to give presentations on it to our affordable housing committees. So it's not a NIMBY, don't do it here, don't do it in Southborough. It's don't do it on this lot. And for the very big reasons, when you see the size of that building, the impact of that to that property is huge. And when it's on a lot that doesn't seem to be buildable for the zoning reasons the planning board has brought up, I think you need to be really carefully looking into that. And what I would say is, the select board, who directs our town council, none of them had talked to any of the entities in town that work on that property. They never spoke to the Open Space Commission, the Stewardship Committee. I have never seen them engaged with the Conservation Commission, and yet they assigned town council to come out and support this. I suggest that we should have a council or somebody advocating for the property that's owned by the town, just as you would if you had an underage child that can't speak for itself. Nobody is taking care of that land and the value it has to the hundreds and hundreds of people who walk it all the time and the wildlife that lives there that cannot speak at this meeting tonight. So on some level, I am trying to let you know we have at-risk birds, we have at-risk bumblebees and butterflies, species heading towards extinction, that are going to be negatively impacted by this development. And that's a conversation for another night on how they'll be negatively impacted. But there is definite negative impact, and I can bring you studies to say why. However, I say, who is speaking for the land if you're not going to have a... when you go to a court, there's two sides, there's two attorneys arguing opposite points of the same law for the defendant and the prosecution. I'm looking at it, not that this is that adversarial, but all we're hearing is somebody who's in support of the project and has not looked at the negative consequences to the land. Where's the counsel for the town interest on that property? And I will tell you, that's the largest property the town owns for conservation. So I don't want to take too much time, but I think the issues about the subdividing is serious. And I also say that there is, I'm not a lawyer, but I do know there's no relief to the non-40B parcel, right? You don't get 40B protection. The town already found out what happens when you give 40B protection to the non-40B component of a 40B, which ended up in court and cost a lot of money in legal fees, right? So we don't want to end up there. And people, unfortunately, think because there aren't abutters that this isn't going to be a legal situation, so we can just slam it through. And I want to encourage you to think you have a bigger responsibility to all the town. That's town-owned land, not just, you know, one abutter. All the townspeople have a vested interest in that land. And go to Breakneck Hill and sit there. See how many hundreds of people walk there within a week. Even within a day, it's nonstop, people coming and going. Speak to the Stewardship Committee how much effort is put into maintaining species on this land that are going to be negatively impacted by this project. So you have a lot that was a variance and a special permit saying no more buildings on it. And it was supposed to be gifted to the town at one point in time. You have a lot that's, when you subdivide it, you're going to create a more non-conforming lot. I don't know how you can have a road that's not a road for a subdivision, and I guess there's a way to do it, but I guarantee if I had an attorney appointed for the conservation land, there'd be someone telling you that, no, you can't do that. And I'm just saying, you're not hearing that sort of legal advice, and I think somehow that needs to be heard. So, and then, once this moves on further, we have other issues if it does go ahead, but I think you need to seriously consider the zoning requirements of the subdivision and the lot left behind, and also giving the land that's left behind the full responsibilities of a zoning subdivision.
Thank you.
Which requires recommends open space.
Thank you.
Paul Carter, 6 Hillside Avenue. And I will agree with Freddie, that all the town residents that use the conservation land are the abutters. And so the statement about there being no abutters is very disingenuous. As far as the legal issues, I really appreciate the fact that the town council has addressed those issues for the planning board. Initially in this project, they weren't addressed. So I'm glad to see that they are addressed now. I think there's still some questions, and I think Freddie's statement that there needs to be legal counsel that represents the other boards, because it's really not quite clear at this point that the ZBA is representing the other boards. That's really their responsibility. It's not the ZBA's responsibility to take over the other boards' work, okay? It's the ZBA's responsibility to take on the concerns of the other boards and make sure that they're taken into account. As far as the preliminary subdivision plan, I agree, the preliminary subdivision plan needs to be shown on the, quote, site plan that the ZBA signs and that gets recorded. It needs to have all the elements of a preliminary subdivision plan in order for it to be recorded, not just an easement. I also say I agree that this is not an A&R situation. An A&R is only applicable if there is adequate frontage. There is not adequate frontage for an A&R plan. Let me just say, I've been doing this for over 40 years. I'm a civil engineer. I manage road and bridge and bike path projects and site development projects. I did 4 years of site development, designing sites just like this with Beals and Thomas. I know a good site plan when I see one. Also, I did planning board reviews for the town of Medway for 2 years. I understand the peer review process, and I understand what's necessary of an engineer to advocate for a planning board and make sure that the town's requirements are taken into account. I believe the intent of 40B is to streamline, and this is on the middle of the second page, is to streamline the permit of these 25% affordable projects by consolidating the necessary oversight and permitting processes so that one town board represents all the concerns of the responsible boards. I'm all for streamlining. Permitting is slowing down very important projects, but there isn't a process adequately, and there has to be, for addressing the concerns of all of the elements that need to go in the permitting process. So the board, this program is good because it streamlines the permitting and the timeframes and all that, but it isn't intent to circumvent the necessary reviews and the necessary considerations that made. Talking about CMR, I looked at the regulations for how this is supposed to be implemented. In section 5607, section 3, evidence, talks about balancing. It refers to the weight of local concern being commensurate with the degree to which the health and safety of occupants or municipal residents are impaired, the degree to which the natural environment is endangered, the degree to which the design of the site and proposed housing is seriously deficient. And I'll go into why I think the existing site plan and proposal is seriously deficient. And I would say that nothing is being taken into account in terms of the natural environment, even on the site and on the adjacent conservation land. The whole side of the hill drains to this location, okay? There's no drainage area plan in the drainage calculations. I've reviewed many drainage calculations, and I've prepared many drainage calculations. One issue, so I believe that this project is seriously unbalanced, as evidenced by the input and comments submitted by the Planning Board, the Open Space Committee, Stewardship Committee, and all the other boards. Granted, affordable housing is important, but we shouldn't be accepting substandard, inappropriate 40B projects in order to get to that 10% so that we can, in fact, avoid having to deal with these projects. There isn't any logic there, okay? Us not getting to 10% is not worth having to deal with these type of projects, and Park Central is no different, and I'm not going to address 250. Another issue is that this comprehensive permit needs to be peer reviewed. There's no project that goes through the town boards that isn't peer reviewed by engineers. This needs to be peer reviewed like any other proposed project. The other thing is, you know, we need a sidewalk, okay? Or subdivision road requires a sidewalk, okay? The Mass Highway Department has gone completely away from highways and gone to complete streets. They now require that sidewalks and bike paths, I won't even talk about bike paths here, are required on all roads. As evidenced by Route 9, they built a sidewalk along Route 9. Would you think we really need a sidewalk along Route 9? Well, this project needs a sidewalk because it needs to connect to that sidewalk on Route 9. And that needs to be part of the subdivision. And I'm sorry if that affects the parking, you know, adjacent to this existing driveway. But if this is an apartment complex, it's going to have kids, it needs to have a sidewalk. The site plan, which I included here, which I think is important because once you get into the details of this, you forget about what the site plan really looks like, okay? Look at the size of the apartment buildings compared to the existing buildings. It's huge, okay? It's completely out of scale. And as far as the four stories, 4 stories make no sense in the town of Southborough. They make no sense in this location. This apartment project is going to have a significant visual impact on the conservation land. It's going to degrade approximately 20% of this conservation land with a 40-foot-high building. The other thing about this site, if you look at it, and I know the boards and others may not be familiar with the grading plan, but they're proposing to cut into the side of the hill with about 15 feet in order to create a plateau for this new building. They're proposing to fill another 15 feet in order to bring it up to the level. They're proposing to create a level pad within a 60 side of a hill that has 60-foot elevation difference across it, okay? Now, this is a site that has major earthwork impacts. This isn't an existing site. Why isn't affordable housing 40B being proposed as one of the office buildings, okay? That would make more sense rather than cutting into the side of the hill here. Water is going to come out of the side of that 2-on-1 slope, okay? That's not going to be stable. Also in the application, there are no perk tests. There's test pit information, but there's no perk tests that show that the subdivision is going to be suitable for on-site. So, the other thing is a dog park and a playground. We're getting a dog park in exchange for conservation land. Walked my dog on that property for 20 years. It's just about my favorite place in the world, okay? So that's what you're talking about with the butters, okay? There's people that feel very strongly about this conservation land. This isn't an ideal, and it's definitely not an appropriate location for this size building. The other thing I spent this afternoon trying to lay out, and this layout is not the most efficient, it's not the least impact, okay, on the abutting land. They can do better. It's not going to be good. I told you all the reasons why it's not the right place for it to be. But they've chosen to put the building within 30 feet of that conservation trail, 15 feet of the property. They've chosen to show a retaining wall right next to the corner of the building. The building doesn't need to be that close to the conservation land. It's a very constrained site, and that's the problem why, you know, it's hard to fit it in, okay? And so it's not the right place for a project like this. And I really want to say that I appreciate town council. I wish he would have gotten involved a little bit sooner. I wish he would advocate for the planning board and some of the other boards, not just for the selectmen or the ZBA. The selectmen were very premature in writing a support letter. That subverted the correct process for review and approval of a project like this, stating that the town, as represented by the selectmen, approve and support this project. I hope the ZBA will take my comments into consideration. I really appreciate you guys have a real tough job, and you're taking on the job of all the other boards. And this is critical, because this affects Park Central. Park Central includes a subdivision, okay?
If we could just stick to this one, please?
Yeah, okay. Well, this project needs to show a subdivision.
Agreed. All right. And if I could, I do want to address at least a couple of things, is
I
that,
appreciate
that of the, when you mentioned peer review, I mean, I would expect that's certainly part of this review. That's part of what we started pursuing with the other 40B as well. I think your comments are accurate. I would expect the board would take those into consideration. My expectation is that a lot of this, the detail, as Freddie mentioned as well, as you break the project down into the different critical elements, that we have a hearing and we talk about those in detail. So I would assure you that the ZBA takes all these things seriously, and we're willing to listen to, the comments. We do like to get the legal opinions from town council, and we appreciate those as well. So, thank you.
Can I just
Yes, go ahead.
quickly?
Freddie.
My position is that we shouldn't go into the other details until we solve, is it a buildable lot? Because, we have town council rebutting some of the things the planning board said, but some of his comments were, well, that's a good point, and, is there another council looking at this? I mean,
Well, if I
provide
could,
that
I mean,
information.
right, I think, I don't know if you're going beyond what planning brought up as far as buildable lot, but I thought that Mr. Talaman looked at that and addressed that already, unless I'm mistaken.
My point was, I think another attorney would address it differently. You have somebody who was charged to see this project move forward, who's going to say, we can.
I'm not clear what you're asking. We have
Is there
town
another
council, you
council?
want to have another council review it? Yeah, a little bit unusual.
Well, we're not, it's not for really this board to wade into how many
No,
attorneys
I wouldn't
the
think so,
town
no.
may hire. And I'm not advocating for or against the project. I'm just here to give you legal
Right,
advice.
it is my, right.
Right, I'm not in a position, I've acted as an advocate for towns, certainly opposing more projects than approving them, but that's not why I'm here. I'm here to help answer questions. On the buildable lot, the 40B locus is buildable if your engineers, the dimensional stuff goes out the window because it's 40B and they can request those waivers. Buildable, the important things for the board to focus on is the things that we've already discussed a little today and that Mimi touched on as well. I mean, we've got to get wetland peer review, we need a traffic peer review, we need basic civil engineering peer review, and then there are more esoteric issues that Mr. Carter raised, such as, what's the impact to the other interests and needs in the area in terms of conservation. I'm not sure I've ever really seen a project get denied and have that denial be upheld just because the land might serve as a benefit to adjacent conservation land, but certainly the available open space, the access to the available adjacent open space is an important issue. That's all going to come out over the next 3, 4, 5, 6 months of this hearing. So we're going to probably in between sessions have the board retain some peer review.
Right.
Look at their engineers' stuff, look at their wetland consultant stuff, look at their traffic expert stuff, and some of the other things. I was very interested to hear the issue regarding sidewalks and walkability. I think that's an important issue. I'm glad it was raised. It's a long process, but buildability of a lot, of a 40B lot is really, that kind of went out the window in 1969 with the adoption of the act, because it was intended to essentially take lots that had limited buildability under existing zoning and provide some relief for that. That's why we're here. And frankly, that's why the statute is controversial and always will be, because it takes a lot of what you pass at town meeting and says you can't really uphold it, except in very limited circumstances under 40B. So I certainly get the controversy and the frustration about that.
So I'll rephrase what I should have said, is that if the 40B renders that portion of the lot buildable, I think the question about what happens on the remaining lot, being a non-conforming lot that now has been maybe not allowed to have two buildings on it at this time, moving forward, what happens there? So you can permit that, but I don't think what happens with the existing lot with two buildings that don't meet zoning code is cleared up, and maybe that's not something for you to consider during your subdivision.
Yeah.
So,
I'm not sure how it would be.
I don't want to really, you have two applications before you.
Yeah.
That project was previously approved under a special permit.
Right.
And that special permit considered only so much activity on the site. It approved it. They need to amend that special permit to make sure it can accommodate a little bit more activity on a slightly smaller space.
Right.
But I'm not aware of a nonconformity that's caused by the basis of there being two.
Right, I think that's what I'm grasping at.
I do think the applicant is going to have to demonstrate in a process that's far more deferential to the zoning board than 40B is, that existing site still functions effectively from a standpoint of your zoning bylaws with less lot area and also accommodating the traffic generated by a project right next door. But that's the applicant, that's why they're here. That's why they applied for it. And so, and as well as satisfying the planning board under site plan approval, which they have to do as well.
Joyce Greenleaf from the Stewardship Committee here in Southborough. I'd also like to speak to this. The Stewardship Committee did send its letter with concerns, which I presume everybody received. And the Stewardship Committee is responsible for Breakneck Hill Conservation Land, which we've heard so many wonderful things about tonight, and is in fact a significant abutter to this proposed development. So I share others' concern that it is spoken of in a dismissive way because it isn't a residential abutter. The Stewardship Committee manages this property for conservation values, biodiversity, habitat, and we are aware, like tonight's discussion, and we are aware of these questions about variances and special permitting needing to happen in order for this to proceed, and stewardship is on record as supporting, as not supporting any modifications to those variances or permits. This proposed building is massive in size and will have significant and adverse effects on the conservation land that abuts it. And those include, but are not limited to, potential damage to wetlands, habitat destruction, wildlife harm, destruction of a historic and iconic stone wall that exists on the property, and the introduction of invasive species through the bringing in of loam, gravel, and fill. That's not intentional, but we know that's a lot of the ways things like Japanese knotweed get spread around the state. And right now, we surveil and monitor and don't have some of those invasive species. And this development could very well introduce them, and it's very, very close, affecting the vistas and walking trails on the property. So I don't want to belabor the points, but we are on record at stewardship of not being in support of the development at that location because of the impacts on the crown jewel of Southborough's conservation land at Breakneck Hill.
Okay, thank you. I don't know if anybody on the board has any comments or follow-up questions based on what we've heard thus far. I'm just trying to figure out what our way forward is here in regards to the special permit, at least.
I have a few comments.
Go ahead, Jamie.
Okay. Just want to address what the speakers just said, and I appreciate everything you said, and I think if any of us sounded dismissive of those concerns, it wasn't intentional. In fact, that was one of the reasons I was asking about the height of the building, is I did consider that it was backing up to that conservation land. I think that's something we're going to have to really discuss as part of this project. I also appreciate the concern about the historic wall. And when that was brought up by someone in the audience, there was no response from council, so I'm sure that they will, but definitely something we want to hear about in the future. So just want to let you guys know that we hear you and that we'll do our due diligence to make sure we look at the drainage and how it's going to impact Breakneck Hill and all the things that have been discussed. That's all.
Okay, thank you.
So not really any questions right now, but just more requests for information, which I think would be helpful for us. I mean, you do have, and first of all, I really appreciate the comments from the planning board, stewardship, and open space committees. It'd be helpful to get responses to their comment letters as best as you can. Just, I mean, be honest, they're pretty detailed, and that'd be helpful for us to understand where you clearly stand on those items. And you may not agree with them, that's your prerogative, but it would just be helpful. I do think we will do peer review like we always do. I think also clarity of waivers versus broad strokes. There are some waivers that are just blanket waivers of entire sections. It's just, at least for me, it's very hard to understand exactly what you're asking for in the waivers versus what the base zone, requirements are. So just additional clarity just helps, to be honest. It would also be great to cut a couple site sections through from the edge of the property down to the parking lot. And this is more of an architectural civil engineering thing, but there is a lot of grade change. So for us, we're seeing 2D plans. And I know there's a topo, and I can read the topo, but site sections that start from the edge of the reservation down to the parking lot would be helpful for us to understand how the building sits on the site. And I know there's some pretty incredible grade changes through that. So they're fairly simplistic to do. So I think that would be helpful. And so that's just helpful, I think, for us and the board members just to understand more information as to where you get, and it just might help speed the discussion process. So those are just kind of additional information requested.
Yeah. Okay, thank you. Just for clarity, you do have all the documentation that was provided to us, like from the planning board and the abutter letter. Are you in possession of that or no?
Yes.
You are, okay, all right, as well as obviously the comments that were made tonight. Just before, I don't know, Mike or Paul or Doris, I don't know if you had anything you wanted to ask or comments to add to the hearing?
Paul here. I have no further comments or questions at the moment. I would like to say, though, I know you already brought up the point that I do feel that we should just stick to discussing the application that we're discussing and not reference or bring in other applications that are pending. I think everything should be standing on its own merit and kept separate.
Right. Agreed. Mike, did you have anything more you wanted to
No,
ask?
I really appreciate, as always, kind of the public comments to really kind of, bring to the attention who the primary abutter is, which is the town of Southborough for all the residents, and the flora and fauna that resides there, and then to try to understand and ameliorate those impacts to the best of our abilities, to the extent that the project moves forward. And I share a lot of those same concerns that have been addressed, whether it be to the height, but also the livability of the project, whether it's sidewalks and access as well. So I'm appreciative of that, and I don't have any other comments at this time.
Oh, thanks. Doris?
I really don't have any other comments at this point, except for that what you were driving at initially, David, was what direction are we going in the remainder of this meeting? I'm hearing from the comments there, maybe I'm misinterpreting it. Certainly, are they asking for a stop because of the buildability of the project? Is that something we should be addressing? And I really do read all the letters, and I'm a great user of the property. So it's more of a question to you, David, and if anybody is misdirected in understanding. There's such a concern by some of the citizens. Um, the discussion of bringing in other lawyers, although we do have town council
Correct.
here tonight. So should we be addressing that, or we just keep moving through the application?
I mean, my opinion is certainly when it comes to the legal question, we have town council. I don't think there's any, I mean, to me, that's why we have Mr. Tallerman here.
No, yeah, we have town council and their council. They're not the board.
Right.
They're council. That's how, if that helps those listening, and that they're council to us, not the decision-making of the board, for sure. Yeah.
Correct. So, I mean, I think we have two hearings, really. It's the opening of the comprehensive permit and the special permit that would need to be amended from the one that exists right now, right? So, certainly when it comes to the comprehensive permit, that's a continuation. I think the only thing we could potentially address is the modification to the special permit, which is, as you said, is just really in regards to the use of the driveway. I mean, that's the
Well, I mean,
extent of it, is it not?
To me, I think you should probably keep them both open until
That's
kind
another
of
option as well.
the end, because the traffic report is going to inform both.
Okay.
The civil, I don't know if there's any civil engineering things, but just basic, the more esoteric elements of your special permit bylaw will be influenced by what you do on the 40B side as well.
Okay.
So I think you should just keep them open.
Yeah, there's really no
and
reason not.
You're building the record. Is there less moving parts per se on the amendment to the special permit? Yeah, because there's not new structures going on that lot, but I think it will be, your decision on that will be heavily influenced by what you learn from your engineers and traffic consultants, wetland people on the 40B side as well. So I think they just kind of get continued. Luckily, under a special permit, there's no real time limit per se. No one's trying to waste time either, but they can follow a similar track on the calendar.
Okay.
Mr. Chairman, we agree with town council that with respect to tonight, not to take any more time up, not that I'm trying to get out of here, that I don't think there's based on Jay's comments, which I agree with, we don't need to go any further on the special permit tonight.
Okay.
We can continue it to the next meeting, and we can see where we are at the next meeting and the next meeting. All we would like to do is to have the board engage the process of selecting your peer review, because that's really where the rubber hits the road.
Right, agreed.
And, then the board gets the information that they can digest, we can respond to it, and we can see if there's a delta between what peer review says and what we propose and how we close the delta, if there's a delta. The comments that were received are all in good faith. And maybe there is something that we need to do to adjust the plan. But the only way we can do this is to have independent peer review. And, all the peer review that Jason mentioned is okay with us. I mean, we're not trying to hide anything, so you need civil engineering, that's going to address this grade thing and grade part and stuff like that. If you want, in that, wetlands is fine with us. And traffic will deal with the driveway and the interrelation between the two lots, et cetera. And again, I don't necessarily agree with the approach as a subdivision, but, I learned long ago I'd rather be a lover than a fighter. So we're going to address all your comments. But as we do that, they're going to get submitted to peer review. And so, they're going to be able to take a look at what we do and comment, as opposed to just coming to another meeting and say, okay, this is a subdivision plan, but peer review never looked at it. So I guess I'm asking the question, probably pretty inarticulately, how are you going to go about, picking peer review, and when do we want to continue the hearing to a point where the peer review will have a reasonable opportunity to at least give you their initial review?
Yeah, I mean, we do have some folks that the town has worked with in the past, and we've reached out to them. I would probably be in favor of following the similar path here. I think one thing we talked about at the other one is I need the board to authorize me to go ahead and make that contact to request it, right? I mean, that's exactly what we
Yeah, I think what we've done in another large project that we're not going to talk about is that the board has chosen to save essentially a month of time rather than getting the peer review all sifted through in terms of the selection of peer review at the next board meeting. The board designates David traditionally
Fine.
to work with Laura and to kind of collect proposals that we think would fit here. And then I think the other thing that the board tries to do is say, because there's not enough time at a single hearing to get through all this, is the next meeting traffic, a transportation engineer, or is it a civil engineer, so that it can be done in sequence? Those are the two biggies. In looking at Goddard's wetland report, he may want to conform it more to the local bylaws interests. And then, we'll pick up wetlands maybe a little bit more as we go, probably not as immediate a concern, although it's certainly a concern that's going to require some peer review. But I would say selection of a civil engineer and a traffic engineer, and it could be the same firm, is pretty important between now and whenever we get back together. And then either that peer review is done by the time we get back together, or we just hear from your civil engineer or traffic engineer next time. And then we follow up with the hearing after that, the hearing session after that with the peer review, just a kind of usual routine. I know you're used to it, Lou.
We're
Yeah.
amenable if we have to continue the hearing to a date certain.
Right.
But if the board was to come back and said, we continue to X date, the peer review needs another week or two or whatever, I would rather do that. I think it's more, we accomplish more if if you have the peer review at the next meeting.
Yep.
I just think we can still make a but then we have something, there's a yardstick for you and the yardstick for, if there is necessary, for our.
Well, with the holidays, that makes it a decent size throw between sessions, because we have to select, get the proposals from, get it approved, and then they've got to actually do the work, talk to your engineer, your traffic person. So it ends up being more like a 60-day, given the holidays.
Again, I think Jason will agree with me. My experience is that once you select peer review and give them the job, it's going to take 3 to 4 weeks at the very least before they can give you a relatively, complete review. And so
Okay.
a couple weeks out from even engaging them with the holidays, you can pick your dates from there.
Okay, I think I'd like to just finish up, if Mimi's back at the microphone, and I think we can get on a little bit later with that, the peer review administrative tasks.
Sure.
Okay, Mimi?
Thank you. Mimi Luttrell, Chair of the Planning Board. Just wanted to clear up 2 things. Attorney Charvel had brought up at the beginning that the Planning Board was looking at overlaying this property for the MBTA communities, MGL, Chapter 48, Section 3A. We are far from that. That we had mapping sessions, and that property got 1 hit out of the 18 tables that we had. So that's not necessarily true. The other thing is the planning board's question regarding 174-14 has not been answered, but we'll try and figure that out. Thanks.
I'll be very quick.
Good.
The applicant's already submitted a traffic report. I don't know whether the special permit modifications relate to the traffic. I can't really see how they do. I think the civil engineering issues are most important, but I think it would be important to think about the peer review addressing not only the plan, but also addressing some of the other comments that have been made, because they relate to the technical review too.
Agreed. Yeah, I appreciate that, the feedback. And again, I would anticipate in terms of peer review, civil engineer review would be important, traffic certainly, of course we do the wetlands. So, but I think it's a good point to say the feedback that's been given here should be forwarded and shared with the peer reviewers as well. So I think the board shares the same thought that we would want this to be as thorough as possible. And we acknowledge that even though it's presented as there are no abutters, we acknowledge the Breakneck Hill. I'm familiar with it myself. I know exactly what you're talking about, so I appreciate it. Okay. All right. Okay, having no other, nobody else ready to speak, we don't have anybody online? No, okay. So I think probably the only things left that we'd want to do, if our position is we want to continue to a suitable date, then we would have to take that administrative task of authorizing myself, if the board agrees, to pursue the peer review with subcontractors. So discussion amongst the board to take that step to do to authorize me to do peer review. Any concerns? Doug, you were on the last one. Other than that, Doris was. So I think to do that, though, we would need a motion with a second and a vote. And obviously for the vote, Doug, you wouldn't be part of that.
So I can make a motion to nominate David, the chair, to be responsible for communicating with Laura about hiring all the peer review
Okay.
people we need
That
in
address
regards to
it, yeah.
this
Yep.
project, something to that effect.
That sounds good.
Okay.
Does it have a second?
I'll second that.
Okay, Paul seconds. Okay, thank you. All right, we have a motion to authorize the chair to engage in choosing contractors for peer review. All in favor, respond with aye. Opposed, nay. Jamie?
Aye.
Mike?
Aye.
Paul?
Aye.
Doris?
Aye.
Right, Williams, aye. Okay, thank you very much. So, I mean, having said all that regarding the peer review process and the need for continuation, what do you anticipate would be a realistic date to have our next hearing where we could, as you mentioned, that to have like a peer review would really be the most valuable piece, right?
I would just throw out maybe the beginning of February.
Beginning of February?
I think just based on my experience, and it's going to take you with, a week or so, and then you're going to run right into the holidays, so
Yeah.
you're not.
Well, if it's not already blatantly obvious, you have much more experience at 40B than I do, so I'm going to take your judgment and Jay's on that.
I was going to say the same thing. Realistically, if we said middle of January, we're going to end up continuing it.
Right, we'll miss
We're not
that.
gonna have any-
Plus, this would give an opportunity, especially on the civil, for the civil to, they'll talk to each other, they can do it, there's a site visit possibility for them, they can.
I think it's a reasonable amount of time.
Yeah.
I mean, lawyers and engineers are, make careers out of continuing things, but.
Right, understood.
So February 7th is the first Wednesday?
What's the schedule look like in February, Laura?
So we wouldn't be able to do here. There's a meeting here on the 7th already
Okay.
scheduled. I can look into the other room at the Public Safety Building if you are set on that date. There's nothing on the 6th or the 8th.
On the 6th or the 8th, you said?
Yeah, if you wanted to look at a different.
I can't do the 8th. I could do the 6th or the 5th.
Okay.
I can do the 6th.
Anybody else on the board have a conflict on the 6th? You okay with, applicant okay with this February 6th?
Yes, thank you.
Okay,
February 6th?
February 6th. And that we could have that here.
Yep, it's open. I'll reserve it tomorrow.
Where's the location?
It would be, I think she's saying it would be here, Doris.
Okay, just,
Okay. I'm trying to remember, what did we do to continue it last time? We don't have to vote on it, we just continue it, don't we? Still have to vote on it, okay.
7 o'clock, correct?
7 o'clock, yeah. Okay.
okay.
Okay,
So, you should do a motion for the
Yeah.
continuance
Yeah.
for both applications.
yeah, so we need a motion to continue the special permit and the comprehensive permit to February 7th, 2024.
February 6th?
February 6th. February 6th, 2024, 7 PM, call of hearing room.
I make a motion to continue this hearing on 120 Turnpike Road related to the special permit and comprehensive permit to February 6th at 7 PM.
Does it have a second?
I'll second that.
Okay. I have a motion to continue to February 6, 2024. All in favor, respond with aye. Opposed, nay. Jamie?
Aye.
Paul?
Aye.
Mike?
Aye.
Doris?
Aye.
And Williams, aye. Okay,
Perfect.
very good. Thank you.
Thank you very much.
Thanks very much. We do need that. Paul? Paul, your job here.
Oh, is it go time?
It is go time.
All righty.
All right, Paul.
Here we go. I'll make a motion to adjourn this meeting here this evening.
Second.
We have a second. All right, motion to adjourn with a second. All in favor, respond with aye. Opposed, nay. Jamie?
Aye.
Paul?
Aye.
Mike?
Aye.
And Doris?
Aye.
And Williams, aye. Okay, thank you very much. That adjourns the meeting.